Good morning, ladies and gentlemen of the jury. In leaving you today, I want to begin by saying that no lawyer has ever had a better jury. And as I sat from over there and had the occasion to watch you, I noticed that you were paying attention and taking notes, if not writing them, at least taking mental notes on what was going on. I know that this has been an inconvenience, and on behalf of Ryan, let me be the first to say thank you for your participation. It's a pretty interesting case, don't you think? This case had reached a point where the investigation had come to a stall. When Mr. Cooper was not indicted, what pushed the DA's office to the indictment in March 11th of this year was him bringing in the people that he paid to make incorrect statements. Now, the most unusual thing about bringing in this expert from Oregon is that he was infamous in terms of what he told jurors, the truth of it, and a very famous person, or a very famous case in which an innocent man had been convicted because he took the stand and he told them that he knew without any doubt that that defendant had to be the person that killed his wife. That's just like he took the witness stand here. It's almost like a replay of time. He gave almost the exact same testimony. The really heartbreaking thing is that what that expert did was he stopped the investigation, because when they focused on the husband, relying on his testimony, they stopped investigating the case. Now later on it was discovered that there was some DNA on his wife that linked to the actual perpetrator. Mr. Engler, who had sent a photographer to take pictures, who had impersonated a scientist, Mr. Engler's employee, who later admitted that he perjured himself, testified for the defense in the third trial. He almost had to do that to keep himself from getting prosecuted. So there was no doubt about the fact that this man has absolutely no credibility. And it was for that reason he was talking. He didn't realize I had any paperwork. And as soon as I showed him a copy of the paperwork, he stopped talking. He stopped talking. So this case, what is this case really about? This case is about jumping to a conclusion, not doing all that you need to do to investigate a crime. I need the screen turned on, Your Honor. Okay. So what I want to do at this point is just go through the testing that was done, because a lot has been made of the chair and the blood that was found around the chair. Remember that? The blood was flowing onto the chair, off the chair, to the left, through the center console, onto the floor. So all of that was tested. All that was sent to the lab. Now, I do want to point something out, that even if you believe it's blood that's under the seat, behind the seat, in that area, all these other places, that blood was never tested and confirmed to be the blood of Ms. Toomer. There was no DNA testing on that. The only DNA testing was on the headliner that was part of the convertible roof. That was it. There was no testing from any other substance in the car or anywhere else that came back to Ms. Toomer's DNA. All right, so let's talk about the very first report. The thing to keep in mind is this. The very first time that the car had been searched, all items had been sent to the crime lab. Whenever they wanted to submit, all that came back as not the scientific definition of blood. All right? In fact, these results were inconclusive. So let's talk about what we're talking about. And I want to begin with the 1A here. That's the passenger's door interior. You remember the last expert said there was blood on the door. Remember, he said it was blood on the door. All right? So the very first test, passenger's door interior, this is what was submitted. Passenger's door interior wet, passenger's door interior dry. Front passenger side between the seat and the frame swabs. So what I'm trying to do here is direct you to what was actually looked at and not just make a vague reference to it, because this clears up a lot. All right. So they're testing, if this is the seat, they're testing all of this. All right. And this is not the actual chair, by the way. They're testing all of this on the side, on both sides, and to the back. Everything surrounding that chair, they're testing under the chair. All right, so when we talk about front passenger side between the seat and the frame, that's this side, right? Between the seat here and the frame. Tested that. They tested it with a wet and with a dry. What they do is they wet the Q-tip and they take a sample. And then they take a sample where it's not wetted, dry. So they took 2 different samples from that area. They also, now here is something that's very unusual. They also took samples of the headliner. So the last thing you're going to see when you get this report, which is one of the state's exhibits, is you're going to see here passenger roof liner dry, roof liner wet. That's what you're going to see when you get to see the actual report. So passenger roof liner dry, passenger roof liner wet. All right, and here are the results that say at the chemical examination. These are the particular items, the swabs, everything that was introduced. That came back as inconclusive for presence of blood. Now, it's inconclusive because they're getting 2 different results. And you see the 2 presumptive tests for blood did not produce the same result. And the reason you can get different results with a presumptive test is that's not really a scientific test. The definition of science is to reproduce a result reliably. This is not science. That's why you're getting a positive and a negative. They didn't do a confirmation test. So she got two different results, no one should even be referring to that as blood. No right-thinking police officer, attorney that works in this space, nobody should be in front of a jury telling a jury that's blood, because that's misleading. These tests are just to help you in your investigation, to show you what to consider on. So no one should be doing that. That's how that man got found guilty of something he didn't do after Ron Engler came down there and said some of the same things he was saying here. You have a presumptive test, then you have a confirmatory test, and then when I pointed out to him, no confirmatory test was done here, he thought that. He said, yeah, I think a confirmatory test was done here. I said, no. I said, actually, the testimony we got is a GBI don't do confirmatory test. Oh, that can't be true, et cetera, et cetera, et cetera. But in any event, he assumed that he had neither a presumptive test or a confirmatory test. And then they went to, oh, I can tell his blood by looking at it. None of these experts had ever said that. Not him, not the other paid expert who works at the UPS store. None of them had said, I can tell his blood by just looking at the blood. All right, well, how can you tell it's Ms. Toomer's blood? Because presumably you would need to test that for DNA. So that's ridiculous. You can't tell that whatever they were looking at was one, blood, and two, Ms. Toomer's blood. We also know that because the investigator who was using luminol, this is the area he's using luminol, all came back negative. And you remember that the only presumptive test he got initially was between the seat, the rear seat, and that was it. So the luminol test was negative, and the test he got back from the GBI, all that's negative. The last sentence in the report is 1A02 fails to reveal the presence of blood. Now it was clear from what Ms. Folks said that fails to reveal means it's actually negative. It's actually negative for the presence of blood. So let's take a quick look at what was 1A02. All right, so 1A02 is the passenger door interior. That's 1A02. So if we knew nothing else from the testing, we knew that the passenger door actually tested negative. Was no question about that. Negative for the presence of blood. So I don't know why this expert would have come in here and said there was blood on the passenger door. There was no blood on the passenger door. There was no question that the passenger door tested negative. So that's the first test. There are only two tests for blood. That's this January test that I'm showing you now, and then the other test is in April. So let's take a look at the April report. All right, so the first thing I want to show you is that there was a sample taken of item 05B. And 05B is a wet-dry swab that was taken underneath the passenger seat. Underneath the passenger seat. That is 05B. All right? And what she said about 05B is the chemical examination of the swabs from item 5B and that's under the seat, and the stains from the piece of front passenger seat. All right, so here they're testing underneath the seat. They're also testing a piece of the front passenger seat. That was the cushion. Both of those failed to reveal the presence of blood, which means they were negative. Which means that when they pulled the seat out, this tested negative. This hole they have here, when they pulled that out and they got the cushion, that tested negative for blood. Now you'll remember in item 6, she did say that there was the presence of blood on the same item number 6, but then she explained that the leather portion, there may have been the presence, but underneath the leather portion, that tested negative for blood. So there's no question that there is no blood in the cushion of any car seat. That specifically came back negative. So why they have the car seat up here and the cushions pulled out, and they're trying to tell you that those cushions, that was blood, that's not true. And you'll have the test to look at it for yourself. That wasn't even a presumptive test about the cushion that they keep talking about was soaked in blood. The cushion is what the medical examiner is basing his testimony that she died in the car, because from the cushions he could determine the number of liters of blood that she lost. That was based on the cushions, that's based on their experiments with horses. That's how they got that. Now all that's junk science, all that makes no sense, but in these cases, it's in these details where you catch them, or where you don't. And when you don't, what happened is the same thing that happened with the person who got convicted and spent 13 years in jail. Now, it meant nothing to Mr. England. He still ain't remorseful. Oh, he sued 30 people, et cetera, et cetera, et cetera. He didn't say, my case got dismissed. I didn't pay him a penny. And if he hadn't paid him, he's the type to be the first to say, I never paid him a dime. What he said? Oh, I can't talk about it. He was quick to bring up the fact that he can't talk about it. He could have said, I ain't do anything then, I ain't do anything now, I never paid anybody. Why would he, unless he had agreed not to speak, why would he be prohibited from talking? He ain't prohibited from talking. He's only prohibited because he entered into some kind of agreement admitting his guilt, because he was guilty. And he knew it. He's still down here defending the man who took the stand and said, I perjured myself. He was still down here defending his employee, talking about his employee did a good job. The man was never trained as a forensic biologist. He was never trained in crime scene investigation. But Mr. English still defended him. You know why? That's what he gets paid to do. He does not charge a flat fee. He gets paid by the hour. You submit to him a case and say, what do you think about this, Rod? If he says the guy is innocent, you know his total fee is $575. That may be split up depending on how quickly he reached that conclusion. So he only gets paid if he extends his, whatever he's doing, whatever he calls it, flies down here, gives testimony. Because he's charging by the hour. So when I asked him, hey, what is the total bill? He said, oh, I don't have it yet. I'm still charging. I'm still charging. Right? He testified on Monday. He testified on Monday in this case. On Monday, we had maybe 1 or 2 brief witnesses. Got him pretty quick, remember? Now, last week, y'all had to sit through a 2-hour video. Remember that? Remember, you couldn't go home on Friday because you had to sit here for 2 hours, right? That's because Ron can't get down here to Monday. So they're playing for 2 hours, torturing everybody in the room, a video, the audio of an interview, when the man had already testified. He had already testified. The officer had already testified as to what he said. They ain't playing just the portion they needed. They just took 2 hours, and after that 2 hours, you then went home. So Ron was also eating up part of your life as you are about to make a serious decision. Because Ron can't fly in until Monday. Ron can't fly in until Monday. The reason the photographer was mistaken for Ron is because Ron wouldn't go to the crime scene in that case. He sent the photographer in his stead. Ron had come down here to look at nothing but pictures. He said it's his second time down here. It was his second time down here. Same for the other expert, so-called expert. Now, you may be asking yourself, it's pretty expensive to prosecute people. Why is it expensive for the state to prosecute people? The state has the Georgia Bureau of Investigations. They could get those experts for free if they're willing to give that testimony. He went outside the system because he couldn't get anybody else to come in and make those claims. That's why you have private experts testifying in a public trial. Because Mr. Edwards decided to use taxpayer money to do something that he couldn't get done through the GBI. You know why? Because this stuff wasn't adding up. That's why. But there's no slowing Mr. Edwards down. When he got his mind made up, there's no slowing him down. There's no slowing him down. It's skipping steps. We know he's guilty. We ain't going to do it. Even Ron English said, you got to have a confirmatory test. No, but ain't no slowing him down. It's the officer saying on the witness stand, hey, wait a minute. We're still looking. We ain't got no certificate of death. We don't have all these other things. Well, officer, let me ask you this. What day did she die on? I don't know. Now, does it sound like Mr. Edwards is listening to the people who have been investigating the case from the very beginning, or taking it into his own hands? That's exactly what he was doing. She's saying that she doesn't know because she doesn't know. The whole case, the whole theory of the case makes no sense if you think about it. They had this boy the whole day. They had him using the car on video. They even have him using the car at 8 o'clock that night. Now, they haven't come back to emphasize that. Once I pointed out, what was the window for him to kill her in? They had him using the car at 8 o'clock that night. They knew exactly where he was at. Remember, after I asked about GPS and being able to track somebody's phone, they said, oh, you could be anywhere. You can be anywhere in Albany. When they put the slides up, he went anywhere. You could see the street address. You could see his exact location. They talk about everything except for how the crime actually happened. We spent most of the trial just trying to get the blood straight. Even if you believe it's blood, they never proved that it's the blood of Miss Toomer. There's no DNA matching on whatever they claim they were looking at, that none of the tests confirmed. The only DNA matching is up above. It was a very small amount. If you want to call it blood, so be it. A very small amount of some fluid that was in the headliner that matched a woman who rode in that car all the time. That matched a woman, if you look at the little incident they got into, she was bleeding that day when they got into that fight. It certainly is not enough for you to jump to the conclusion that Miss Toomer was shot to death in a small vehicle, with there being no gunshot powder residue anywhere. When you fire a gun, one of the things that comes out as that bullet is traveling are particles, and these particles are part of gunshot residue. That gets trapped into fabric, into clothing. They found absolutely no gunshot powder residue, but that didn't stop it. Getting back to how he committed the crime, if you take into consideration at 8 o'clock he's in a store using Miss Toomer's card again, then he either committed the murder before he went into the store or after he left, but before he went to work that night. So they left Dawson, I think, the officer said around 4 o'clock, 6 o'clock, to get back to Albany as he's preparing to go to work. So if you believe he killed her during that time, he has to shoot, kill her, then dispose of the body. The body, according to them, is just pushed out of the car. You will still be able to track the car off the road to wherever he presumably dug a grave, buried her inside, and covered it over where no one was able to find it. It is completely bizarre. This is completely a work of fiction with no happy ending. That's not the way, if there was a way, to get away with murder. This is something that would come from a television show. They have him in the middle of town when he gets back. That's confirmed by their own cell phone mapping. They have him, if you believe he killed her at some point after he left the store, killing her in the middle of town, not in some secluded area outside of town. The timeline doesn't work. If you look at the time and the location where he was at, there's no way that he killed this woman during the time that they say. That's why the officer said, I don't know. In the indictment, it says she died on August the 15th. I'm sure they may come back up here now that I've said it and try to say, hey, look, you don't have to find that she died on August the 15th. Well, they owe some investigation to you, ladies and gentlemen of the jury. They're putting the case to you now as though you could investigate this case from the jury box, which you cannot do. You can't issue subpoenas. You can't interrogate witnesses. They're asking you to do something that they couldn't do. Since the disappearance of Miss Toomer, they haven't been able to find her. They claim that she died. I get that. But it took them an enormous amount of time to reach that decision and ultimately to get these experts. And they still haven't figured it out. Their case makes absolutely no sense. And it didn't start making sense because a man who was in jail in Terrell County did what every prisoner in jail does, which is he tries to get out of jail. They try to get out of jail by implicating somebody. The somebody to implicate obviously was Ryan Cooper, because the officer had come to talk to him on 2 prior occasions. He realized that he was valuable, and that's why he made up this story on Ryan Cooper. There has been no one to come in here and say they found brain matter in the roof. That was completely ridiculous. They're saying that his being in jail has nothing to do with this case. I grant you that. That's not the point. His wanting to get out of jail has something to do with this case. His wanting to get out of jail has something to do with this case. And he wants to use Ryan to do that, so he can get out of the prison that he got himself into. He can get out of the prison that he got himself into. But the state is asking is that you essentially help him get out of jail. That you essentially help them prosecute cases like this in the future, which not only would take away the life of an innocent young boy, but also cost taxpayers an enormous amount of money. The tab they'll ultimately get for using these private, whatever you call them, maybe $50,000, $60,000, or $70,000. The services they provided to the district attorney's office was free. The GBI gives the same testimony, only if it's warranted though. You can't get them on the case. You can't use the medical examiner to claim that someone died and to give a cause of death when they have no facts to rely on and they disagree with you. That's why there was no medical examiner from the state of Georgia called to testify. They don't explain that. Why didn't their own medical examiner call this a homicide? Why did they have to go and get someone who worked out of the UPS store and lives in South Carolina to come down here and, according to him, give an opinion that is so obvious that anyone in his field could see it? Like, I've been doing this for 30 years. I can tell DNA on sight. Well, if it's that obvious, then why didn't someone from the state's medical office sign off on it? Sound like it's routine if you listen to him. He got to stand, he sounded so confident, different than what he put in his cut and paste letter. When he was saying that, you know, all of my observations, everything I'm telling you is dependent on actually examining the body. Him and Mr. Engler are nothing more than snake oil salesmen. They come to town, they tell you what you want to hear, they give you something that makes you feel good, and they make you think that they are exercising some kind of expertise, in which they're not. All these men were doing was getting paid and trying to secure a position in the Dory County District Attorney's Office where they could get paid in the future. Because one of the things you could take from the way they testify is that they want to come back to give the same kind of testimony, to pick up another check. That's why he was down here. That's why he was down here. This is a tragedy, not only because we have the disappearance of someone and we don't know why, but also because the state wants this young boy to pay for a crime that they never investigated, that they have ignored all the signs that point away from his guilt. And I would just ask that we not compound one tragedy with another. Thank you very much.